Good morning and welcome to the California Board of Occupational Therapy. We are coming to you live from Samuel Merritt University in the Occupational Therapy Department. We are very pleased to be here and we thank this team and faculty for having us on campus. With that said, the time is, we want to thank our public for your patience. We are starting at 10:19, and if we could go ahead here and do a call to order to establish a quorum.
Here.
Here.
Board Member Palovich.
Here.
Board Member Witzakbach.
Here.
Secretary Doe here. Vice President Marcos.
Here.
And President Miller.
Present.
We have quorum.
Thank you.
Everyone's present.
At this time, moving on to agenda item number 2 for the president's remarks. I actually just had one remark specifically, and it's for those of us who are in the occupational therapy world. We recognize that this is a California Board of Occupational Therapy, and of course, this is a regulatory environment. But we work very close with our colleagues and practitioners at the American Occupational Therapy Association. They're many times our public members. So it is with sadness that I want to just announce a very long-term brother for many of us at the American Occupational Therapy Association, and that's Lance Bank. Lance passed away unexpectedly July 9th. It has hit the occupational therapy community quite hard. For those of us who've grown up attending the conferences and things, it has rocked many of our worlds. It won't be conference. I've been to 30 conferences and I can't remember a conference without Lance. And so as we go into our conference coming up next year, it happens to be in a city I don't love, Orlando, so I guess it'll be okay that Lance won't be there. No, I can point out that being said, I just wanted to acknowledge that in this OT community. I know that many people on this board also had a relationship with Lance, and specifically our practitioners in the state of California who are longtime volunteers with Lance Bank. With that, I want to open the meeting and just acknowledge him and send our thoughts and condolences to his family. Thanks. With that, let's move on to any board member remarks. Any remarks at this time? Seeing none, let's move on to...
Maybe we could congratulate Chiquan Shea on the NBCOT appointment.
Would you like to do that?
I just wanted to acknowledge Chiquan Shea and her appointment to the to NBCOT, or election to NBCOT board. And thank you for hosting.
For those people who are part of our public who are not as familiar with the terms and all the acronyms, the NBCOT is the national board, the certifying body for our profession, and one of who will be introducing themselves soon has been newly appointed to that board. So congratulations. All right, and with that said, for public comments not on the agenda, what I'd like to first start with is to invite our public who would like to introduce themselves to please do so. You would actually come here and there's a microphone here. You would come on up and you would introduce yourself. You're not obligated to do so. And I want to start first by having the board welcome Yvonne Durantis, who is the Assistant Deputy Director of Board and Bureau Relations with the Department of Consumer Affairs. So we're grateful for that. We also want to be thankful to Samuel Merritt University for having us. And with that, we'd like to invite our public and anyone up who'd like to introduce themselves.
Thank you very much. And I'm Chiquan Shea. I'm a faculty member for the Department of Occupational Therapy at Samuel Merritt University. And this is my first time attending the meeting. So thank you for coming here and allowing us.
Good morning, everyone. Carlin Daly Rayom, the Advocacy Chair for the Occupational Therapy Association of California, also on faculty at University of Pacific in the OTD program and private practice owner.
Hi, I'm Dominique Embry, and I'm one of the faculty here at Samuel Merritt University, and I'm also a consultant at the California School for the Deaf.
Hi, my name is Yvette Murray Cook. I am new to Samuel Merritt. I will be their new chair and associate faculty, so thank you.
I also just want to take a moment to thank our public, and also to just so that for people who are watching to know that we're supported by a pretty incredible staff, our executive director, and we have a number of staff here that we know support our consumers and we know support our practitioners. So we're grateful for that. We also have our very esteemed colleague and legal, Helen, who's with us, and we rely on her a great deal to guide us through some of these the language and such. So thank you, Helen, for your expertise. And with that, we're going to go ahead and move forward to item number 5, which is review. Oh, okay. Actually, if ever, let me go back. We've actually received a public comment. It's part of, I would like to find a highlighted one. So, okay. Did you pick it up? Go ahead and hand that back to me, please. Okay. So, we have a public comment, and to summarize, I'm going to summarize the public comment. What's before us as a board is we can't respond to the public comment, but we can put it on the agenda for future. Now, the context of the public comment is actually an agenda item, so we could also possibly address it. Well, we have a short snippet on the fee.
If the public comment is relevant to an item on the agenda, it can be read at that time, or we could read it now and then refer to it during that public item.
Okay, so that public comment, the first public comment is specific to the fee increase, and that item is on the agenda for tomorrow. So in the interest of time, I would like to table this till agenda item 20 and go from there, okay? Everybody good with that? The next item is we have a public comment for an agenda item that is it's on the agenda today, and this is regarding pelvic health. It seems that it would be better to take that in context as well. It's agenda item 11, so we'll be doing that. So our 2 public comments, one's for today, agenda item 11, one's for tomorrow, agenda item 20. Everybody good with that? Okay. All right. So moving forward to agenda item number 5. Review and vote on approval of the May 18 and 19 board meeting minutes.
I would make a motion to table this until tomorrow, so we have time to review the minutes tonight to approve it tomorrow. Since we just
Seems
got it.
reasonable. Seems reasonable. Second. Can we do that? Sure. Okay, great. We're going to take item at the request of board member Lena Doe. Also, it looked like there was agreement by board member Pavlovich, and this is a reasonable request. We are going to table item number 5, review and vote on approval of the May 18th and 19th board meeting agenda or board meeting minutes, and we will take that first when we come back tomorrow. I know that just as a technical piece on each item, I do go to the public and ask if there's any public comment. You have a right to comment on every agenda item. So we're on agenda item 5. We're on minutes. Just asking the public if you have any comments on that. Okay, great. Moving forward, we'll be bringing that back tomorrow, so get your comments ready if you'd like to talk about this meeting. Okay, moving on to agenda item 6. Executive Officer Update on Public Law 117-333, portability of professional licenses of service members and their spouses. So if we could turn this to our Executive Officer for her update.
Thank you. So in your materials is a snippet of a 1,000-page federal bill, and it starts on the front page, starting with section 705A, portability of professional licenses of service members and their spouses, and it goes to the top of the following page. Since the first page is what is applicable because California is not in a licensure compact, but basically under the new federal law, service members or their spouses can provide a copy of their duties copy of their orders showing that they've been assigned here, and then they are allowed to practice here. They do not have to get a license. The Department of Consumer Affairs, though, is, however, working on a registry system that would not be inconsistent with the federal law, and it's merely for keeping track of individuals, so that in the event there is, for example, a complaint of patient harm, then the state that the individual has a license in, the state of California, would be able to notify that state. This went into effect January 1st. And so it's a federal law, and that's the update on that. And once that system for registration is up and available, which I believe will be soon, then I'll have an update on this at the November meeting.
Heather, any questions from the board about this? If you just did, I didn't completely track on it, but can you tell me what it used to be and what it is now? The end game?
There used to not be a law, and now there is. And this is a federal law that allows basically transportability of service members. So when they have orders to practice in California, they or their spouses can do so without requiring them to obtain a license.
So the next follow-up question on that is, what does that look like in everyday practice at our board? What does that mean? They apply, they come forward, it's not a limited permit. What happens?
Well, it hasn't happened yet that we know of, but I mean, without this registration, there's they could be practicing and we wouldn't even know it. For example, since the law went into effect January 1st. So the registration is really, it's only, it's not to limit their practice. I mean, it's to basically, again, keep track of them in the event that there's a complaint.
Keep track of them in the event there's a complaint, but if they haven't registered, how are we going to know there's a complaint?
Well, we won't until there's a complaint. I mean, that's the thing. It's kind of, I don't know how to say it.
Statistically,
Like if there's no harm and they're working here and nothing, then and they don't register, we wouldn't know. It's really that the people who are practicing without issues wouldn't really come on the board's radar. In the event that there was a complaint that there was harm, we would be able to contact we'd be able to investigate it, but also notify the other state where they have a valid license.
They don't ever have to apply for a California license?
They do not.
The limit, wow.
Part of it's because they're movable and portable, right? They move around a lot, so it's with their service and those kinds of things, right? Okay.
And this is the federal government's way to recognize that they do move around a lot and to give them, as long as they have a valid license in a state, to give them the ability to practice without, frequently getting new licenses.
Thank you.
Can I ask a question? Yeah, so one of the things that we talk about with the licensure compact is that they added some states don't do background checks. The compact requires states that are participating in the compact or people participating in the compact to get a background check. But military people would be subject to background check and vetting by the military itself. Is that but they wouldn't be required to do a background check in California if they moved here, right? Under this.
They would not.
Yeah, so we would be relying on the fact that they're in the military and they've been, obviously, that's a floor in terms of criminal activity and that sort of thing. Sounds like, okay.
So what did you think the language meant on the top of page 2 about interstate license compact? Because you and Heather have done a lot of work on that. We've tabled that discussion for our practitioners, but is it saying that they don't have, if they don't have to register, then why the call out about the interstate compact? It just didn't make sense to me.
My take is that if they are part of the compact, they would be subject to the requirements of the compact, which would include a background check, is my understanding. In order to participate in the interstate compact, OT compact, they require a background check. And all the other requirements of the compact. So it would kind of grant those, it would mean that the compact would sort of apply to military people, but it also doesn't apply to military people because they don't need it to practice.
And it's them and their spouses, just to make sure I understand.
Who's ever ordered here.
Who's ever ordered here.
And has a license. So if the service member is ordered here and they're not a occupational therapist, but their spouse is, it allows the spouse to practice here. Because they have a license, as long as they have a license, valid license in another jurisdiction.
Okay. Any other questions, comments?
So with this, I think it would be a more kind of like a beneficial for us to like delve deeper into the interstate compact to protect our consumers by, adopting this compact in the state of California, because then that way we get the background check, the registration, all that stuff to make sure that we have a record of them. So I guess this now, kind of pushes us forward to say we need to make sure that maybe we do what we need to get this compact in the state of California to protect if this is going to pass in the federal government, right?
Absolutely. I'm so glad that you made that comment because that's exactly what I thought. I know that we've tabled our discussion around the compact, but this particular update, does it behoove us this is the piece where we watch it and we see what's happening federally. It's not like the compact, there are no compacts in California, but it doesn't mean that we as a board can't continue to look at the foundational aspects of that. Being the policymaking body, it is within our authority to protect that consumer and continue to explore this. So.
I think we've been tabling this discussion because there was nothing, beneficial to us. But I think if this is on the horizon and this is going to happen, we as a regulatory board need to protect our consumers, and we need to seriously look into the elements of the compact and get it into the state of California to make sure that we are protecting the consumers in California and ensuring that someone doesn't slip through, because that's what we were talking about with the compact, right? We wanted to make sure that someone from another state who violated their probation or whatever, violated any issues or got in trouble, didn't slip into the state of California and practice because they couldn't practice in their state. But I think this kind of makes it even more essential that we look at it deeply and strongly, because this is going to really pass in the federal government. Because we want to believe that everyone that's going to come in here and practice is good, but we have to do our job and do our due diligence to make sure that the consumers in the state is protected. And that's our job.
I agree with that, but also in the first set, in general, not the one that just specified the interstate license, I think they can still though come and not be part of the compact. So we're still not closing the loophole.
But I think that's what that we know the best is if we have a contract, we need to make sure that it includes that just because you're in the military does not exclude you from, being part of it.
I understand that, but the federal law still allows them, as long as they have a good standing license, they can still
But
come.
it doesn't say that I think we have to this is a legal matter, like, does the state's rights oversee the federal law of this? That's the thing that we need to figure out. This is my realm where we need to delve into see if, this is gonna supersede anything in the state, So if it supersedes anything the state passes, then what's the purpose of the interstate compact,
Well,
right?
Go for it.
We have an attorney here who might want to weigh in on that.
So, to somewhat follow along here, the federal law is enacted and allows those who are licensed in any state, if they are transported here, either the military personnel or the spouse can move here, and that was deemed appropriate in order to allow those families to continue to gather an income or practice or whatever they needed to, rather than our standard process, which in California we do have an expedited specifically for military, but not all states necessarily do. And so this was the federal law, which would override even the state law to make sure that they can practice. And they arrive day one, they can practice, and the license they would show would be the license from their state, which would be, we'll say North Dakota. So they would show their North Dakota license. DCA is building in a process for them to be able to register with us so that they can show, first of all, we're aware of them, and that also they can show that they are lawfully able to practice in California without having to pull out federal law. If a state is not a member of the compact, then the compact is it's a whole separate entity from the law. So the law applies to all military service members and their spouse. Doesn't matter what state they are from or Puerto Rico or anything like that. So if we have a compact, it may override the compact, or sorry, the federal law in the background check portion, because the federal law doesn't mandate that. It simply says one license here is as good as it is there. But if that member state becomes part of the compact, then we have the background check, and we have all the issue, or all the certifications and protections that we have built into the compact. But if North Dakota is not participating in that compact, the military service member can still, or their spouse could still come here and still practice regardless of the compact. So at this point, DCA is still maneuvering for kind of a DCA-wide position on this, or safeties. But at this point, the federal law allowing them to practice day one is in play. If our interpretation at this time is that if they are licensed to be able to perform a practice in their home state, that they could not practice here. So if occupational therapists could assist with births in North Dakota, but they're not allowed to do that here, they would not be able to do that here. So they are still working on some of those details, but essentially if you're in California, you are practicing like a California licensee. But as for the background check and whatnot, that would all be subject to that home state. And if they were members of the compact, and any other options we may build in the future. But they are licensed, able to practice, and we are simply recognizing that. A very similar, although obviously not quite the same, as a driver's license. So if someone who can drive in North Dakota, they can drive here with that driver's license. But we are working to try and get a little more transparency for our public. But the member, or the practitioner, also does not have anything that indicates that they are California licensed either. So until they would register with us or receive a temporary or permanent license with us.
So, just a point of clarification so I understand. So, aside from the compact issue, so if a military person was licensed in the state of North Dakota and they came here under the military law and they were practicing in California, they would not, let's say they were, I don't know what the law is in California, North Dakota. But let's just say they're allowed to do physical agent modalities and swallow. Is that was your question? Okay. Swallowing, our advanced practice areas. They would not be able to do that here in California
So
unless they can meet, or how would that work?
that's a little more specific than I have.
I gotcha.
So essentially, because I think you're not the only board that would have, my guess is what you're saying to me is there's occupational therapy and then there's occupational therapy plus swallowing or plus this. And so if someone is licensed to handle swallowing in North Dakota, then theoretically they would be able to do that here.
Well,
But that's still not only some details are being worked out, but that might be a little more than I can answer
I gotcha.
from my position.
Okay. Cute.
Any other comments? Thank you for that discussion. How about from our public? And please come to the mic. And also, just as an acknowledgement, we've had another public member join us. You are not obligated to introduce yourself, but during this time, if you'd like to come up to the mic and do that, this would be the time.
Good morning, everyone. My name is Jack Klein. I'm licensed under Elizabeth Klein. I'm an occupational therapist and faculty here at SMU. Is that all you need to know?
Welcome.
I was going to offer you a resource, which is we have a former faculty member here named Elena DeLamba, whose husband is also an occupational therapist in the Air Force and very high up in the Air Force, and she's an occupational therapist, and she has been doing research on this area for a long time. He has since been transferred to Texas, but while she was in California, it was an issue for her. I only helped her code her research, so I can't speak to what she found. But one thing that did stand out to me is that it was less than 5% of military spouses who have a career that requires a license. And she did a national search to find people who could meet her research qualifications. But I think she could give you a lot of good information. So, and I can give her information to Jody. Yeah.
You know, it would be great, Dominique. Thanks for acknowledging that. It'd be great if you were to inform her about this discussion and ask her to write a letter to the board if she has time, or to do a comment, or to just weigh in. Are there other ways for her to weigh in?
Give us the analysis that she found.
I know. I don't know when her publication target was, but I can find out for you. Yeah. Yes.
So less than 5% have a career that requires a license at all, or in
Yes,
occupational
at all.
therapy?
Yeah.
All.
Yeah, because
Even a smaller percentage of OT.
I don't think she found any OTs in her national search besides her and her husband. When I was coding for her, there weren't any conversations OT. I remember radiology techs. I remember computer analysts, but I don't remember any other healthcare. Oh, nurses. There were a fair number of nurses.
May I ask? So, I mean, if you're working in the I had occupational therapy colleagues who worked in the VA, and for a time their position was they did not have to get a license because they were working for the military, for the VA system. So when you say when you say that only 5% required a license in the military, you don't require a license.
But they were not getting jobs on the base, right? These
Yeah,
are the
only if they work
spouses
off
who
base,
were going to
right.
go work other.
But if you work in Germany as a pediatric occupational therapist at a military base there, you wouldn't require a license.
Okay, go for
I don't think.
So you are correct. When you become a licensee and you work for the military, that license under the military is good for all your military service. So as an attorney, if I worked for the military while performing service for the military, I could practice in any state, any jurisdiction, and advise the military. The minute I were to walk off base or turn to someone and handle a legal matter privately, then I would need to be licensed in that particular state, or it would have to be a California issue. So that would be how someone in the military who has an OT license would function. But a lot of this is for the spouse so that they can also supplement the income of the family as they normally would, or for members who are performing one job but do something on the side. So, but yeah, if they're working for the military, their one license generally is good for as long as they are working for the military and to the military.
And I know from our experience here at Fieldwork, we place students at Travis Air Force Base, and they have very specifically said to us, we do not want the partners of people who are active duty on Travis as students, because there's a hierarchy here and it creates uncomfortable interactions. So and every time the spouse, the student wants to go to Travis because it would be very easy for them, and we have to say, no, if your spouse outranks your supervisor, it just gets uncomfortable. I don't know that that's true for spouses, but I imagine it would also be true that they're not usually hired on the base.
Thank you.
Yeah.
So, Helen, on the top, thank you, Dominique. Oh, please.
Hi there, Carlin Daly Rayom. I just wanted to echo what the board member brought up related to potential of advanced practice areas and just kind of figuring out what that might look like for those people who would be practicing in the state of California. So no specific additional comment besides to just say that that's a concern, I would say, from the professional association side of things. So thank you all.
So, Carlin, interestingly enough, 2 of our board members are committee members of that practice committee, and you are more than welcome to join that committee and weigh in on that topic with them, right?
Great, happy to help. Thank you all.
We appreciate your comments. Thank you. Did you notice, okay, I don't know if this is a connection, and then we can certainly move off this topic, but did you notice on the top of page 3 page 2 of this item, Helen, it's 1, 2, 3, and 3 is not a license to practice law. So they called out law. So everybody's universal, but what's going on in your field?
Lawyers are special.
Can I ask?
The practice of law is deemed to be so specific to the region, whereas
makes
to the body, it's the body. And so that is what I understand to be the reason for the separation. Also, much like we were talking about with background checks, some states simply having an ABA accredited, American Bar Association accredited education is good enough to get a license and maybe even transfer. But in California, you can get education or qualify to be an attorney through multiple methods, including following an attorney around, which is what like Kim Kardashian did, or reading all the books. So the big barrier to make sure that you are qualified to be an attorney is the bar license, the bar exam. And there's only a few states where they refuse to accept anyone who doesn't take their particular exam because that is their qualifying mark. So it gets a little weird, but because the law is so specific in each individual state, they could not practice here, there, and everywhere. Now, if they're advising the military, again, they're only advising the military about military things, and they usually can contract with another attorney for anything that might be specifically local. But that would be my understanding as to why we were exempted.
Any further comments before we move on? Okay. Thank you to our public for the comments. So we are whole on agenda item 6. The action item for it appears to be, and it's one that we don't need a motion because it's just about agendizing it. I did hear from board members that we want to watch this, and we want to watch this as it relates to the license compact, interstate compact.
No motion is necessary.
Yeah, I'll have an update at the November meeting.
Perfect. Thank you. All right, moving on to agenda item number 7, update on functionality changes to Breeze. This will be given by our executive director.
So you may recall that Breeze is the online system that has an outward face to the public, to the licensees, and then there's an inward face that the staff uses. And this is a listing of the various changes that have been made. So, for example, during the governor's executive order related to the pandemic, people who had an expired, canceled, or retired license could reinstate that. And so that since the governor's order, executive order, has ended, that functionality in Breeze was removed last year, allowing licensees to upload documents. For example, your certificates of completion at the time of renewal is another one. Waiving of fees for active duty military spouses. That includes the initial license fee as well as the renewal fee. We previously had a demographic survey, except that the Department of Healthcare Access and Information had standardized some language, and now the demographic survey that the board had was previously was replaced with this new HCI survey, so that for all the healthcare boards, the same demographic information would be collected. Just going down the list, allowing licensees who didn't either licensees who were on probation and wanted to submit a petition could now do so online. And then that way that helps them get into the queue. We can ask them for paperwork and then, schedule it for a board meeting. I'm just keep reading these. Well, I mean, so,
I have two questions for you.
Yeah, okay.
If I may. The HCI Workforce Planning Survey.
Mm-hmm.
When that's added to Breeze, what information will we yield about our licensees? Do we know?
I have not requested any reports on that. Are you wanting us to? I mean, one of the things you have to know, though, also is that the survey, both at the time of initial application submission as well as at renewal. So every time you renew, these same questions come up, but they're not required, right? So licensees can choose to not provide answers, or some do all of them, and then some don't. They might just identify gender and language spoken, for example.
Right. Well, let me ask the rest of the board, because here's what my thinking is, or why I'm asking the question. For many, many years over time, at different times, we've talked about surveys. I don't know what this survey will yield, but I imagine it might give us something more than we have. And I imagine our board is also contributing to a portion of paying for these Breeze updates. Is that correct?
This has already been taking place.
Yeah. So I would think, as a board that has participated, and I would like more details. So,
okay,
not that specifically how we might apply these items to things we're looking at with future licensees. It just it just keeps us informed.
Okay.
And it lets us know and we recognize they don't have to fill it out, but we can also use that as part of our outreach when we speak at conferences to tell people to fill it out once we understand what's on it, because it might yield us some good info. I don't know.
Okay, we'll put that on the November agenda.
Everybody good with that? Okay. And then, is it called out on a line item? How does payment, when you say it's already taken care of, how do we know how much it costs and how much the board?
Well, we have a Breeze budget, so
is that called out in your executive report? I'll wait for
I don't know that. So yeah. So
you want me to bring it back in your report tomorrow?
Yes, please.
Yes, no problem. Okay. Any other questions from?
I just had one about the separate discipline and conviction questions. I thought we weren't allowed to ask conviction questions at all.
Can I ask about convictions of applicants?
Oh, okay.
So it's still,
These are renewals. Okay.
But the problem also is that it was a very compound question, and so now it's separating it out into two separate questions.
Thank you.
Are we situated in our own internal operations for, like, if they have a new transaction for pocket license, are we? I'm sure we are. It's just a.
It's a drop down request, and then they make a payment, and then
And restore a retired license to active status. But that would,
so if someone puts their license on retired status and they want to activate it, now that's a new option online as well.
which would be tied into that fee of what is active.
Correct.
Okay, all right.
And they can now upload the documents to support
Correct.
the fact that they've completed
Yes.
continuing
It
education.
wasn't online before. They would have to contact the board would email them a form, they would send in a form with a check, and so it's just it's more convenient to provide the automation and allow them to do that.
So there's a cost for the automation, but there's also a savings from not having a staff member opening the mail and processing paper forms.
Well, we don't have that many. Can't remember. I think that's in my report. How many go retired to active? We're probably talking, 15 people a year. So there's not much savings there in terms of the time spent on the mail.
I was very happy to see that all of this was implemented, and I was wondering, is it a little bit easier on the staff now? I mean, a lot of these that we had workarounds, and now it's less workaround. So. And it's more together. All the information is put together. Yeah, this is really great.
Not within our scope to go there, but for the purposes of moving on, I'm curious about those 15 people that would go from retired to active, just from an anthropology standpoint.
I know where they're working.
Yeah. Why would you ever? But that's just me, and that's not within scope of this item. How about any board members? Any board members have any further comments before we go to public? How about our public? Do you have any comments on this? Okay. Well, even though it's optional on some of these items, hopefully what you understand is it gives the board information so that we can have a very complete understanding of all our licensees in the state of California, and that keeps the consumer safe. There's the tie-in. So, and this allows for you to also, it's pretty helpful to have email addresses. It's not required, but it's very helpful to our board staff to have those items so that we can call on you for committees, help us weigh in. Why are you laughing? Call on you for committees. Expert witness. Well, only takes 7 shares to gain 7 times, right? To gain a share of your mind. So I'll be saying committee 5 more times in the next 2 days. Okay. That being said, no comments from our public? Okay. We are moving on. Now, I wanted to ask support a question. I recognize that we just started. I do think that we're going to take a number of little breaks. I do want you to know the next section we're going into is lengthy because we're going to go by it page by page. Here's why. We're talking about proposed language, and we're talking about language that, for the most part, the majority of the board has been here through all this language. Some have not been here through all, so it's not like we're going to go lengthy. I just want you to know we're going to go page by page to make sure our understanding of what the changes are is good, and then we'll be going towards a motion. But does anybody need a break, a quick, less than 5-minute break before we start this process? Okay. Then what we're going to do, it's 11:03. If we could take a break to 11:08, and then we will come back and we'll move into agenda item 8. Thank you.
It's funny.
Welcome back. The time is 11:16. I don't know, it must be this Bay Area air. We're all a little loose on the time, huh? Including myself, right? It's very nice up here.
We're very laid back.
Very laid back. Yeah.
Sometimes.
But I'd like to welcome our public and welcome people back to the California Board of Occupational Therapy. Today is Thursday, August 24th. We're coming to you from Samuel Merritt University, and we're very appreciative of that. We are on line agenda item 8. Our approach to this is that we are going to look at each page of the language. Heather, if you could cue up the action item of what's before the board. As we review number 8, we're looking at proposed regulatory language. If you could cue us up, that'd be great. Oh. I do not want you to go. I want you to tell the board what the end game is.
Okay. So in your materials are the proposed regulatory amendments that have previously been seen by most of the board. Some of them we've lumped together them multiple sections into what we call a package, right? So item number 8 has amendments to 4 different sections. That's in one package. Because it's been some time since you all saw this, and to establish a record, this is on your agenda to re-review what you have already approved. Okay, so it's not that you can't make changes, but just as a reminder, everyone's seen this. The intent again is so we have this on the record that the board is approving the language, and I will take any questions. I'm not sure. The end game is that we want a motion at the end to approve the language and get it noticed so we can move forward. Not in this package, but in the next one, for example.
No, we're going to stop there.
Okay.
So, on the standards that we have before us, the office, what we want to be mindful of is we're preparing a packet, we're looking at language, we're here together with the board, and in order to move this forward, we want to keep in mind that these standards that are in the regulatory language, that the Office of Administrative Law has specific standards. And these standards, as we as a board are reviewing this, and that's why we're going page by page, we want to be sure that all the proposed regulatory amendments are that we have the authority, that there's necessity, that it's clearly written, and that it's consistent, and references, and there's non-duplication of items. So these are the things that are before us, and as we move through this, I'm going to move through it each page because we have so many documents before us. I'm going to move through quickly, but what that really means to all of you as a board is you need to stop me. We're board making this entire decision, so if I don't catch you or something, please just interrupt so that we can get this done and make sure all your comments are collected. Okay, so that's what's before us. Is that aligned? Okay, Helen, are we good? Does that align as we go forward? Okay. Yes. And then, all right. And then, as we look at the proposed regulatory language in agenda item 8, the sections before us, there's 4 as identified by our executive officer, Heather, 4110, 4111, 4112, and 4114. So, the 4110 is about applications. Anybody have any comments under applications about the language?
I appreciate seeing them all in one place like this with the forms that are incorporated by reference. The only question I have has to do with the form. But I have no concerns about the language, which I do recognize as having seen before.
And by form, you mean the initial application for licensure?
Right, the initial application for licensure form. It seems the date is changed at the bottom from 9/2020 to 1/2024. I don't see any other changes, so I'm wondering if I'm missing anything. And I do want to bring up the gender section because that has come up and will continue to come up without a non-binary or other option, and what the reason why that is. Just if we could address that, maybe Helen and
Well,
other.
well, one of the things I can tell you is that Breeze does not have a binary option right now. It still has only two genders.
Are there any,
Drop down.
the question will come to us, are there any plans for Greece to consider that you know of?
If I may, once Breeze is updated, then a change on the form could then be made in order to incorporate that change. But if the system doesn't permit it at this time, it's beyond our scope. So, but certainly the executive officer can make a note that once that is a capability, then these forms would again be changed.
Has there been discussion about changing that at the Breeze level?
There is discussion, but I don't know how detailed it is and how much of an impact to IT this would be. And so there's a lot of factors going into play. But we are aware that this is a topic of relevance.
So it's a topic under discussion.
Yes.
In DCA. Thank you.
I'd like to just continue with that same thought. I think a lot of us had that same concern. Richard, thanks for initiating it. Because I want it in the minutes, it'd be nice if it could be open text box. And I'm not sure, according to the law, if there's places for 2 or 1 comment, but if we were open to open text box, something like, what gender do you identify with would be a fabulous question. If we needed to know because of licensure what you were born with and what you identify, it could be a 2-part question in terms of what was your gender identity assigned at birth, follow up, what gender do you identify with? So an open text box, I think, would be very nice to have. The male, female is we can't have that.
I don't know if I understand what that looks like. An open text box, and we ask those 2 questions, which
Yes.
is what a public member identified.
Well,
Okay.
that would be like the public member right here who now identifies as Jack and is licensed as Elizabeth. We would like to know when you do your initial license that now you identify as male, I'm just assuming, or go by they, them, whatever, as non-binary, but then at the gender they were assigned at birth is male or female. So we would know that as an initial license just for our information and background, because in the future, I think we had this at the last meeting when we were talking about how do we protect the public when, someone may do their license as, Jane, and then later changes their name to John. How do we protect the consumers if the, license is under Jane, but now the practitioner goes by John? So we just want to know in case, that this is an issue and this is, concern for demographics. So we want to know, that we have it so that we know that, who we are, who our licensures are, but then also, just in the future, if we need to protect, consumers know that, this is what's going on, because we had that whole issue about, looking up a name and finding out all that stuff.
Thank you, Lena, very much. So we do have a public member who wants to make a comment, and if you just can bear with me for a moment. Did you want to respond at all, Heather, on what we do now? Or does it make sense to go the public and then have you give this?
You can take public comment.
Yeah.
Thanks. Yeah, Jack Klein. Thanks for bringing up the topic. It's actually a really big topic that would require a lot of discussion, I think, when it's appropriate for that to be on the agenda for the board. I was just noticing that on the Friday agenda, there's a Senate Bill 372 that says licensee and registrant records name and gender changes. I don't know what that includes or how that might be addressed, but as far as determining what the fields should be. Should there be sex assigned at birth, gender identity, what the dropdown would include? Is it an open field? That's a big conversation. It can't be as simple as male, female, non-binary, or prefer not to disclose. If that's an option, that's okay with on the records, because there's a lot of different identities that people use, different language people use. So just highlighting that it's a significant topic of discussion. And I think a lot of different organizations are grappling with how to make forms more inclusive of the population.
So Jack, I have a question for you, if I may. So it is a more involved conversation, and it is one where we have to rely on people who are in the know and would advise on that. What I'm grappling with, and this is why I'm asking the question, I'm really asking for your input. So what's before us is proposed regulatory language. Proposed regulatory language on 4 items that also involve a form of which a lot of conversation has taken place about gender. Do you think, and I think I guess where I'm trying to go is there's a difference between, there's not a difference, it's not the right word. There's regulatory language and there's humanity, and they intersect in so many ways. Do you see this as something that, is it enough that, I'm struggling with not moving a package forward without having I'll just put it out there. I'm struggling from a regulatory standpoint of not putting a package out there because of this item. It doesn't mean that the humanity side of me is not going to keep working on it. I am, but, and so my question to you is, do you think it's enough to say?
I have to say I'm not sure that
Understand my
I think I do, and I don't think I understand the process enough to understand if this is moved forward as is, how difficult it will be to continue this conversation and then revise in the future once the conversations occurred. Because I do
Well, here's what made me feel better, if I may just interject. What made me feel better as I was grappling with this is that our attorney said if Breeze updates it, it opens the door for the discussion again in a bigger way. And so that gives me a lot of direction. Yeah, optimism and direction that when we have a system that goes that way, the discussion's goes that way.
Yeah, I mean, I can certainly say from a personal standpoint,
Because the alternative is we don't get this language approved.
yeah, I hear you. It is something that needs to change in my view, because it's very difficult to sit in front of a form that has 2 options, neither of which fit me, and having to pick one that's not accurate. And it's in many places, but so I do hope that there is I don't know how we poke Breeze to make that change, or I don't understand how Breeze and the board are connected. So I won't stand here and ask you to hold up the regulatory language right now. I won't. I'm not that person. Just hope
But
that
you would weigh in and help us get to when a system, I'm just talking a systems piece, as a system, when a system changes, you will continue to give us input along the way to make sure that as these things, as a representative of all our licensees, he, she, them, the non-binary, that type of, that you'll continue to give the board input to help us get there.
I would be happy to. Yeah, we're even doing that here at SMU. We have a meeting today to talk about what options to include on our forms.
Got it. Thanks for that open, back and forth so we can get to action. What other?
I was going to say, this is the whole thing about why we involve the public is that this is your opportunity to stay involved and to keep us accountable and make sure that, when you see changes happen and it doesn't look right or doesn't feel right, because I was telling fellow board member that when I looked at the form, it made me feel really bad. And, I'm lucky that I identify as, my gender at birth and all stuff, but, when I look at a form, I get very irritated when I'm like, there are not options. And, but as a public member, this is my job. I think when I said that I wanted to be appointed, it's like, I am the disruptor. I will speak for the people who are not, doesn't have the voice at the table. And so this is the kind of things that when I see it, I'm like, this is my job right here to get this form changed. But, as long as I'm on the board, I will make sure that all these gender issues and all these forms are correct, because we need to be reflective of the diversity of our state. and our country. And we start very simple with just our state, right? And so thank you for stepping up and speaking. And thank you for providing me an example when we were talking about it. But, you know, that's what we're here for, right? Is to protect consumers, ensure that our licensees feel that they belong. And that's very important. It's about belonging. And if we are preventive by putting these things on the forms, no one will want to say, fill out a form and like, I don't feel like I belong in this profession. I need to find a different profession, right? And so that's, you know, my 2 cents.
Thank you. Board Member Pavlovich, you had a comment earlier, after the discussion, did you want to weigh in at all?
No, I appreciated Jack's commentary. I just want to make sure that we keep that in mind for further discussions. And I'm not familiar with the capability of Breeze, but I don't want to just let it go easy if we have a chance to fix it in time.
Thank you for making sure that's on the record. Good point. And, okay. Anybody else have any?
I just have one thing, which is there are 41 boards and bureaus, and they use, I think they all use Breeze, or most of them use Breeze. So, and we're one of them. So, if each of the boards made a request about in this area to DCA about what, is there a time frame for addressing this, and what's the process for addressing this particular issue? That's the way. It's not going to get changed just because we ask, but having but if we don't ask, then nothing will change. So I think that we have that ability. Maybe if we could ask TCA as a separate action item, or getting an update at a future board meeting,
That's a
something,
point.
just so we know is something going on or not going on. And then I'm prepared to support this now because there's nowhere to go with the data if we were to collect it in this form, because it goes into a database that has 2 options. So
Perfect. Just, Heather, you have a meeting, don't you? All the executive officers have a meeting, right? Mm-hmm. So to board member Bookwalter's point, I think we're asking for an action item to just let them know this came up in our meeting, and if they could all address it, or however you want to word it.
Will do.
But I think you've got the takeaway.
Yep.
Okay. And the next, so
do you need a
that
motion?
was page 1. We are going to need a motion. I just want to take it a little, so on the that's the application, the place of filing. What was added there is submitted to the Breeze system, review of application, the taking out of certificate, the adding of the word approved. All of these were good changes and they've all met the standard of being within our authority and necessary and clear and consistent. And there's non-duplication, as well as abandonment of application. Again, the word, it's changed from 60 to 90. Approval, again, applicant fails to complete the word, the application is taken. And then there's also a clarity of 30 days, and any application fee forfeited if the application is deemed abandoned. So do we feel like this particular regulatory language meets the packet? And if we do, Helen, in terms of introducing the motion, am I able to, how can I approach this? Can I share
Certainly.
this with a board member?
Certainly. So
Whichever board member wants to make a motion, I'm going to share some language with you.
if I can give some context,
Number 8.
the regulatory unit has been working with OAL in order to make sure that all the pieces of each package is well documented and specified, and so they've provided language in order to adopt a regulatory package and allow some flexibility in order to make sure that it is 100% before it goes to OAL. And then this was also, that kind of generic text was also
edited specifically for this board in order to make sure that we had all the pieces and the board could make separate decisions on each motion. So there is a text of motion or a text of the motion, which is a little bit lengthy, but that is the
And
purpose.
it's two motions, so
Correct.
just to be clear, what's before us, there will be two motions. One's going to be about the regulatory package, and then one's going to be about the direction we give to the executive officer. Do other board members have?
No.
Okay, if
So,
you could pass one down this way in case anybody wants to make the second motion. Thank you. Okay, thank you for that. Okay.
Are we ready for a motion?
Before I go to a motion, do we have any further comments for our public? From our public, this regulatory package is specific to these four items. The form is included. We've discussed an item on the form. We've put an action item out that's within scope for us with our executive officer. Anything else you want to comment on? Okay, I think we're ready for a motion.
Madam President, I move to approve the proposed regulatory text amending sections 4110, 4111, 4112, and 4114 as presented, and direct staff to submit the text and other required documents to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. Take all steps necessary to initiate the rulemaking process and set the matter for a hearing if requested.
We need a second.
I'd like to second.
The second was by Beata. She jumped in first, but
She
if
beat
you
you.
share that language, we'll have you do the next motion. So the first is by Richard, the second is by Beata. So we need a roll call.
Board Member Bookwalter,
Aye.
Board Member Cabrera,
Aye.
Board Member Palovich,
Yes, with hesitation.
Board Member Wittelsbach,
Yes.
Secretary Doe, yes. Vice President Marcos, and President Miller.
Yes.
Delegate.
Motion carries.
So we do need a motion. I
do the
don't,
next one there?
Hector, if you wanted to make the motion, starting with I move to delegate, or if you'd like Richard to do it, whatever. We just need a motion.
Okay. I move to delegate to the executive officer the ability to make edits to the texts that are consistent with the law and substantially similar to the text of the policy approved by the board at the meeting.
We need a second.
I'll second.
So we have a motion, thank you, Board Member Cabrera, and we have a second by Board Member Bookwalter.
Right. Board Member
Sorry about that. We're going to take public comment in case.
Okay. Board Member Bookwalter,
Aye.
Board Member Cabrera,
Aye.
Board Member Palovich,
Aye.
Board Member Wittelsbach,
Yes.
Secretary Doe, yes. Vice President Marcos,
Aye.
and President Miller.
Yes,
Motion carries.
great. Thanks, everybody. Okay, moving on to. We are going to move on to number 9, which is consideration and possible action to initiate a rulemaking package to amend CCR Title 16, Division 39, Section 4102, filing of addresses, Section 4151, hand therapy, Section 4152, physical agent modalities, Section 4153, swallowing assessment, evaluation or intervention, Section 4154, education and training, Section 4161, again, I'll repeat, Section 4161, continuing competency, and Section 4162, completion and reporting requirements. So now when we go to agenda item 9, we see that on page 1, there is a lot of language we've worked on the address of record. Just giving historically that the language that this board is coming up with and proposing has been based on the change of address being one of our biggest offenses. And so this particular language that we've deliberated on and talked about really has to do with getting a clear and concise way of language to that consumer, the practitioner, excuse me, to know, to inform the board of any address change. Do you want to add anything?
This is also modeled after a couple of other boards as well.
Thank you.
That's why it's so lengthy.
Anybody have any input? We're going to take these section by section so we capture 4102 filing of addresses. Anybody have any input on the board? Any?
I just have on the second page, under D, where it says does not require an applicant or
One
license.
second, I'm sorry. Can you hear her on audio? Because she does not have a mic in front of her.
I'm pretty loud.
Okay, go
There
ahead.
you go. No, it's right here. So the section says this subdivision does not require an applicant or licensee to obtain an email address. It only requires that person report an existing email address to the board. That doesn't even make any sense because the requirement is so like, you can say, oh, well, I don't have it. Anybody could just say I don't have one. Does not make any sense.
It's E and F.
It's under D.
If I may. So, although email addresses are free and whatnot, it's not for the government to impose upon a licensee to force them to have an email address or to become competent in computers. While we all are there are potentially some licensees which are not or do not have the capabilities such as internet and whatnot. And so this allows that flexibility that if you have one, report it, but you're not mandated to actually have one. You are mandated to have a location at which point we could reach you.
I think the way it's written, it's kind of like chunky. And I get that's what I understood, that if you have an email address, we ask you to report it, but if you don't have one, you don't have to report it. That's what they're saying. But the way it's written is very chunky and very, I want to say legalese.
Can you say that, the way it's written, can you say
Okay.
that statement one more time?
Yeah, so the way it's written, it says that if you have an email address, we as a board are asking you to report it. If you do not have an email address, you don't have to report it, and you're not required to get one. That's what it's
That's
written.
not how I read it. I read it as you could provide your sister's email address if you don't have one, or your husband's email address, your wife's. As long as you report, you do have to report an email address.
No. But you're
You
not.
know, it said it only requires that person to report an existing email address to the board, so I'm
The
assuming,
last sentence says it does.
yeah, so the existing email address to the board would mean their email address, not any email address.
Yeah.
But it's saying that if you don't have one, we're not asking you to get one. Yeah, it's just very chunky, and because I've read so many policy papers and stuff like that, I understood it, but, I know that any, like, regular public member reading it, they might, like, say, what the holy
You
macaroni?
require this, but not require
Yes,
that.
that's what it's saying.
So ask your question again one more time, your comment again one more time, so I'm not sure I see it that way, and I want to try to see it
How do you
that.
see it?
I see it clear.
Well, it's not fair, right? Almost like if you have an email address, you're required by law to do something about it. But yet, the ones that don't have it, they don't have any requirements. They just get away with whatever.
But I think it also gives you the opportunity that if you have one and you don't want to report it, you don't tell them, right? Just say, I don't have one. But
Exactly.
that's,
So,
but it's just
requirement
saying
doesn't
that we
make any
want,
sense.
it's saying that we want your email address, but if you don't want to give it to us, you don't have to give it
That's
to
what
us.
it's really saying. That's what, no? That's
No.
not what it's
It's
saying?
Not saying, it says you are required
Required.
to report.
Exactly. If you have one.
Which
So how is
page
it
do you see
fair?
that? Is that D?
D.
Okay.
It says, the last line says, it requires that a person report. And it
Exactly.
requires that a person report.
This section shall not apply to any person.
No, it's,
Under D, the last line.
No.
yeah. No.
This subdivision does not require.
No, but then here it says does require that person reports the existing email. That's what doesn't make sense.
She's saying we're asking for it. You don't have to report it. I'm saying that it requires that they report it.
Yeah.
So the words require is
The word that's
the
wording.
word.
Because require means mandated,
Exactly.
not like a
Optional.
soft
I could
ask.
see that.
So you cannot say it, right? You can get in trouble that, oh, you had one, but we don't know if you have one, right? Assuming everybody does, but yeah.
I don't know how they would know, but.
Exactly. But the law said, so you get in trouble if you didn't report it, because that's what it says here. But you can just say, oh, I never had one, so I don't have any liability there or requirements. We're not-
Plus, I have 4 email addresses, so which one do I report? I mean, it's kind of an odd
Oh, as long as you
situation.
report one, doesn't matter.
Yeah.
Actually, it does say as long as you report one. So to me, and seeing this as part of the filing of the addresses, the whole thing, I read it to mean that email addresses, if you have one, we'd like you to report it. If you don't have one, it's not required. If you do have one, we'd like to have it within 30 days, although the subdivision says it's not required. So I did see that back and forth, but that's really, I'm only sharing my thought to help us get, the majority of the board had questions about it, so maybe we can get to a good.
Can we change the word require? Can we say
Can we-
it only asks that the person, not instead of saying required, saying it only asks that the person report an existing email address to the board?
We can, so I'm sorry, Board
That's
Member
okay.
Doe, that I was speaking when you were, I heard the first part and
So-
turned to ask if we could,
Yeah.
but we have a
Yes.
few comments from our executive officer.
Yes,
Yeah,
yes.
yeah, okay. So whoever makes the amendment, whoever makes the motion, can you make the amendment that we change the word required to ask?
It may be helpful if in the first sentence, it is changed to say, may file a current email address, and that it only addresses that a person report an existing email license to the board, make those two changes. But this is also one of those things that, as not the regulatory attorney, that we would want to delegate with that second part of the motion or that second motion, so that we could get what the board needs with that type of language. So changing a shall to a may is a substantive issue, but if may is not going to work and some other magical word will, then that still gets us to where the board needs to go. So would that, something along those lines be appropriate? Or acceptable, I should say.
And only because I can't remember what two boards this language is combined from, that this language in particular regarding email address does come from the PT board. They've had this language in effect, this same exact language for many, many years.
And have they had any issues? Do we know?
I don't know that. I'm just, all I'm saying is
Yeah.
that this language was modeled after two other
Right,
boards, and this part in particular was modeled after the PT board.
I mean, we have a longstanding issue is that we can't require somebody to give us an email address, even though we would like to, and that we've had trouble getting hold of people. So this, I think this
So
is trying
you
to
think
do
that
the best of
goes
two
there?
worlds, yeah, because
Do you think the last sentence, when you read it do you think that accomplished that or not?
I think it's fine for now until we can pass at some point the mandate that people provide an email address. Of course, email, a lot of people don't even use email. Fewer people use email than used to, it seems like, but
And if I may, some of the historical background to the email address is that now that seems to be a highly visible way to contact people. Most people are using emails and whatnot, although like we've said with the name change, sometimes it's hard to, the address change, sometimes it's hard to locate people and whatnot, and that this is just one more step in due process in order to communicate to our licensees. But because we can't force them to have something they may not be able to have, that's probably why it's worded this way. So there is that tension between, we want to be able to contact you, we need to know where you're located, and we certainly should have all the methods to contact you that the public does. But we have that little tension of, we can't force you to have an email. But as for the actual wordsmithing, is there something that we could do to move this forward?
I mean, I'm okay with the wording. I mean, it's like you can't force somebody to have a telephone, and you can't force somebody to have a computer. and can't hold that as a requirement of licensure. So this is getting around that, even though it would be highly unusual, I would say, for any practitioner or licensee not to have a telephone and not to have a computer or an email address.
And that is a good point. I think that we've reached a point in the language of the law where it says thou shalt report a phone number, but we can't force you to have a phone. So I think it just is that lovely area between law and reality.
Going to our public, is it clear to our public that you don't have to have a email address on file? Anybody? In all this language, is your takeaway that you're not required to have an email?
I do read it, I read it as you are not required to, but if you do, you have to provide it. That you are required to report it if you have one. That's how I read it.
Any suggestions for us?
I did think kind of the may rather than the shall conversation might help it. I certainly understand the purpose of having email addresses and reaching people, but I do feel like a small shift of a word would help navigate that. Thank you.
Thank you so much.
I don't like the may. I think people should, if they have an email address, they have to report it. If they don't have any, but if they don't have an email address, okay.
Free to go. But if you don't report it and you have one, you get in trouble.
Right, because you've got some maybe illicit business going on through your email that, or you're not reachable. A lot of things could be.
Once you get it, you have to report it within 30 days.
So just as a time check, we're on the first one.
You're right.
Just as a time check, everyone, we're on the first one, and we're on an email address, and we will come back. We will come back. How about we try this approach? Let's sit with that thought. Let's
fine.
move forward, and if we feel so moved, we'll come back to it. Cool?
Sounds good.
Okay. 4151, hand therapy. So we've added in the provided, the approved by the board when acquiring education and training. We've, when performed as part of an accredited, that's also very clear and specific to consumer safety, and that the training and education hours must meet the following. For those of you on the board who are in this area of practice, do you have any thoughts on those hours, input, anything that you want to, are we in the right spot?
I have a question that maybe
Yeah.
anybody could, I read this and I think I understand it. The only query I have is this specific to advanced practice hand therapy, or is this talking like if you're an OT? Okay, because anybody could kind of work on the hand, right? This doesn't preclude them from working on a hand if you're a regular OT and you see them as a stroke and you're working on hand therapy.
This section is specific to advanced practice, which is surgery injury to the hand, wrist, or forearm. Yeah.
So I had a question too. Can't we call it advanced practice hand therapy? Do we have the ability and suggest, here's why, because when I read it as a practitioner, I saw it as hand therapy.
Within the statute, I believe it's the legal definition of hand therapy is defined. So this is a little bit taken out of context, but it's clear in the law in its entirety.
So you're satisfied?
Yeah, I look at this all the time.
I would follow you. I mean, this is your area of practice. If you say it's clear, I'll
It's
pause.
completely clear.
It's also in the section that's Article 6, Advanced Practices. That's the title of that section as well. So that language is not on here, and that could have provided maybe a little more context.
You're saying Article 6 above it is called advanced practice, and then all these items are under, okay.
Correct, and there's a
That is-
4150 there were no amendments that precedes this, that has some definitions, so.
Got it. That makes it very clear. Then I see why it's so clear to you, Board Member Weedless. Okay, any input?
I speak in favor of the language as presented.
Okay. Are you in favor of moving, everybody good if we move on to 4152?
Yes.
Okay. Physical agent modalities, and this is maybe used only when, let me pause for a minute. Does anyone from our public want to say anything about 4151?
On behalf of OTAC, we just want to thank you all for your work on this, and we are in support of the language, and we recognize how this can be covered in clinical accredited programs and also clinical placements, and so that those hours that students spend focusing on this, that this could be recognized in support of further practice. So thank you.
Thank you, Carla. Okay, in favor of moving on to 4152, physical agent modalities. This is also another area about wording language that includes approved by the board. It's also about hours, and then it identifies who can perform it and really clearly outlines that.
So I'm so grateful, and this has been a lot of work for us, and I feel I'm so happy to see this in front of us, because when I joined the board, I felt there was a lot of gray areas, and people were, oh, I can do this, but I wasn't trained, so I didn't understand it, but I'm so happy now it's in black and white and eliminating all those gray areas, so.
With the physical agent modalities or all
With
of them?
physical, all of them actually.
That's
It's
great.
just more black and white, and even just reading it, it makes me feel much better about it, so.
I do have a question, just for clarification, and maybe I forgot, because I'm thinking about educational institutions, right? It's very clear, I mean, on the top, it says accredited occupational therapy program under A, and then it says the requirements, right? Must meet the following requirements. It says education, 30 contact hours. When I get to number 2, and it says completion of 240 hours of supervised on-the-job training, clinical internship, or affiliation, which may be paid or voluntary. So that sounds like education institution field work, but what if there is a class, a whole quarter class on physical agent modalities that doesn't fall into this? Are they still required to get somewhere? Can they, if the class is 30 hours, are they able to contribute that 30 hours to this 240? Is that what that means? Because you know what I'm saying, if they go on field work, very few students get hand placement as field work, right? But if someone's teaching a class on PAMS, like how do they negotiate those hours?
So what you're bringing up is a really good point, because many of our curriculums are now adding some of this physical agent modality. So I gather what you're suggesting is that the language would expand on-the-job training, clinical internship, curriculum, coursework. You'd have to tell me if this is even possible where I'm going.
Because 240, you're not going to reach 240 in a quarter, so if they do reach, I'm wondering what that looks like for a class and not someone that's at field work, right? If they have a physical agent modalities class, you know what I mean?
Well, so it's a little bit more complicated than that, because one, the education and training, they has to be beyond ACODE standards. So that fieldwork placement is not going to count, right? Unless maybe they did 2, or maybe they completed their fieldwork and then they did, like, say, an extra 3 weeks. If that's, hours are considered beyond the ACODE standards, then they could count that. But there's also another requirement that the supervisor must have a supervision agreement with the student, or, with the trainee, lack of a better word, So I feel like there's multiple touch points that might not include what you are talking about.
So the schools that are implementing physical agent modalities in a quarter can only reach number 1, but not number 2.
Correct. And also, the schools are doing that, right, because it's a new ACO requirement, not for the board's purposes.
Okay, and they cannot, because it's not above ACO standards, contribute any of those hours to 240. It has to be beyond education and beyond fieldwork.
For the supervised training, that, again, it would have to be beyond ACODE standards.
Because that was a question that faculty had, like, can any of those hours be counted? And the board's position is no. According to this language, it cannot.
Christine knows this better than me.
This is a long discussion that we've been having on this board about, I mean, since the law was passed in 2000 and the requirements were passed soon thereafter, and there is an awareness on this board, and over the many meetings, all the years I've been on this board, we've been talking about what, as the A code standards change, when will they achieve the level that would meet the standards in our law, and there's been a dialogue with A code itself about that, asking that question. When are you gonna match this? Because that's what we determined. Are you ever going to get to this point? And they haven't gotten there yet. But every so often we do a review, and that's one of our things on our agenda item for future board meeting and the practice committee, and there's some other. So that's. Right now, we're just looking at this law, but that's another conversation that we're having in parallel to this one, as to how to, at what point can we have all of these advanced practices been folded into ACOT standards, and maybe they could be relaxed because they're already part of the basic education. The whole reason they're here is because they weren't.
And I think last time OTAC was here, they made a comment that said, hey, schools are really fulfilling, we're fulfilling ACOT standards, as Heather has said, but that discussion of will there ever be a time where PAMS is not considered advanced practice because we're covering at school, the answer is going to be no, because it's always going to be beyond ACOT standards.
May I speak? Okay, so this is a really, really big topic, and I haven't been at the board meetings for the entirety of the discussion, but so I'm old enough to remember, I've been around long enough to remember when the law was passed. And the intent of the reason we have advanced practice areas is because at the time there were no ACODE standards regarding these content areas for curriculums. And every school didn't offer education in these areas, right?
Yes, there was no national minimum education standard that ensured.
Right. So the language of the law was it had to be beyond ACODE standards, whatever was offered. But now ACODE is changing their standards. So I think going forward, the question is, like, how does that term beyond ACODE standards really fit the intent of the original law? And I mean, I think that's something we need to think about, because once ACODE standards comes up to that, then
because we're talking about the 2000 ACODE standards, not the 2023 ACODE standards, and
so I mean, and this is just too huge for us to even get into right now.
Okay, so it's no, the schools won't be able to, is what I'm getting right now. All right, just so our schools are aware.
I want to just make sure to Sharon's initial question and your response as well as others on the training. You've explained it in such a way that the takeaway is no. Is that right?
In a nutshell, yes, it is. The answer would be no, except for if there were these other qualifiers.
For two, and I think just from the colleagues that spoke to me, we're really excited about this, but I think when we have another discussion, then they realize that this is a hard no. Right, there'll be another conversation in educational institutions we'll be having as well.
So we have a comment from the public?
Asking a clarifying question. So if there were an elective course that is not a part of, it's above the ACOT standards, but an elective course that students could opt into, is there space for those hours to count as it's written in your understanding?
For the education or the training?
Either.
Well, I would say yes for the education, but for the training, again, I mean, a supervision agreement is required. I mean, there's other criteria that aren't and isn't in other sections that isn't before us.
Okay.
So
there are schools already who are using courses.
Yes, there are.
Yeah.
Okay. Yes.
And the easiest way to do that is to get that course pre-approved.
Right.
Right, and like, so they would explain which ACOT standards are met and how these ones, go beyond that.
Yes.
So
Okay, that's helpful. Thank you.
education, not training.
Okay, any further comments on 4152 or discussion? We've heard from our public. Moving on to 4153. Again, you're going to start to see universally that what's outlined here is approved by the board. We've inserted that language to make it very clear. The completion of the contact hours. In this one, it becomes very clear on the language that the practitioner has advanced practice in understanding the anatomy, the pathology, the interventions used. And the supervision may also be by a speech therapist in this area, physician and surgeon. Any discussion here? Okay. Did you have, no? Any discussion from our public on this item? Moving on to amending, you want this adopted as an entire package, right? Okay,
Yes.
got it. Amending section 4154 to read as follows. So in this, these are amendments. Heather, do you want to give any?
One of the biggest elements of this is in section 4154A4, that requiring this new application. So we had an application before, it was not incorporated by reference, which is a requirement to specify a form name, number, and revision date. That form, again, was not included in the regs. It's here in the package. Now, if someone wants to take a look at, this has been what organizations and or university programs have been completing when they're wanting their course to be pre-approved.
Again, I want to just pause there and let everybody hang on the fact that we didn't have a form, and we have a form. This is a big win. This is a big win for the consumer. It's a big win so thank you to all the board members who've been on this both before and who've worked hard on this with staff as well. Any thoughts? How about input from our public? Any comments? Okay. Moving on to, the only question I had under actually 4154, all the way down after number 5, we have reviewers, correct? I just want to understand board process. We have
Yes.
reviewers that are subject matter experts that
Yes.
review this and they approve the course, right? We have
Correct.
a whole process. Do you mind just quickly saying one or two statements for our public so that they know it's a very intact process about?
I would defer to Christine because she's a reviewer.
Please,
Well, I'm not a reviewer anymore, but I was.
Used to be a reviewer. She rejoined the board.
please, Christine, that'd be great.
Yeah, I'll make it very, very brief. So if a course is not already pre-approved, right? Then what will happen is basically it's a very long and arduous process for both the licensee applicant who's trying to get their advanced practice approval and for the board to gather, for the licensee to gather all this information about the curriculum vitae of the person who presented the course and all this information about the course and answer all these questions about what they learned from the course, and then all this packet gets sent to a reviewer. The reviewer looks over all this information and sees that it satisfies the requirements set forth in the language that is on the previous page, that all the content areas and things like that. So and then the content reviewer sends that information back to the board and says, I recommend that this course be approved or not be approved. So it's just, there's a way to get non-approved courses approved for advanced practice approval. It's just much more difficult and just takes a lot of work on the applicant's side. So is that what you needed to know?
Yeah.
Yeah.
That's very helpful.
Yeah.
Especially being here in the academic environment, just as part of our outreach, and because you're here, we would hope that you would share with your colleagues that practitioners who are graduating would understand there's an advanced practice, that there's a form, and that it is something that's required by their license.
And I'm sorry, Richard, can I just add to that real quick? And I would say, like, if you were offering courses in your academic program that were above and beyond ACODE standards with regard to the advanced practice areas, it much behooves you to try to get that course pre-approved so that any student who went through that course, it would automatically count. And then the tragedy for courses that aren't pre-approved is if an applicant were to go to a bunch of courses, submit those courses with their advanced practice application package, and then find out later that half those courses didn't count. Like, that's a lot of time and money invested that might end up not counting for that person. So I would advise your students, either make very, very sure that course is going to count by looking at the requirements for the course, or ask the board for their list of approved courses already and take those approved courses. That would be my advice.
Thank you for
I don't know if Richard had anything else to add to that.
Well, I just had and maybe this is a question for you, Christine, because you were on the board previously. The one thing about this form is that this board has never had a form, and it's not because the board didn't think about it. It was because the board wanted to leave flexibility with the applicants to provide the information in whatever format is appropriate for them, and didn't want to force them to fill out a specific form because it gets very bureaucratic. And that's my understanding of why we never had a form up until this point. That's not the case?
That's not the case.
There's been a demand for a form for many years, and the board has resisted creating a form.
This form has been in place for many years. It has not been incorporated by reference in the regs.
So you did the form when?
It's been around for years.
Okay.
It just hasn't, they haven't talked about it in the regs.
Right.
It has been required.
It has been required.
It has been required.
Yeah.
Okay.
But it just.
So the statement earlier about we didn't have a form and we have one, the accurate statement is we didn't have a form in the regulatory language and now we do.
Correct.
Does the form need to be dated? Like the other form has a date at the bottom, and for revisions, any revisions that happen?
It's on the other side.
Oh, it is on the other side.
Yeah.
I'm sorry. I was looking at pages 2 and 3. It's on page 1. Okay.
Okay. Thank you for all the input there. Any further feedback before we move on to the amendment around section 4161, which is about continued competency? Anything you wanted to weigh in on the amendment?
No, also because some of the changes are ones that were just approved last year, that this is another reason this package didn't move forward, because as soon as the public comment came up about, we think you should include, ethics or culturally relevant practice, we kind of sat on it because we didn't want, just from a process standpoint, have a package moving forward with amendments to section 4161 when there was consideration of additional amendments. And so this is another example where, we kind of held it until now. There haven't been any new recent ones. Even on the next page, on page 6, in the middle there, you can see the board approved supervising a doctoral capstone student also, and made the PDUs earn, consistent with supervising fieldwork. So again, all of those happened at different points in time and through different meetings. And again, we just didn't move forward when the policy was before the board and up for possible, amendment.
Denise?
Please.
I just want to, just for the purpose of clarification, because it might not be clear, we're not talking about advanced practice anymore. Continuing competency refers now to just any licensee who might be applying to renew their license. So just want to make that clear. This is not specific to advanced practice. It's just renewing your license and what's required for that. Continued education units or other things that you can substitute for
As is,
that.
right, as is the section before, so the earlier ones that are 4-1 numbers are related to the or excuse me,
4151 through 4154
Four,
were
right.
related to advanced practices. 4161 and 4162 are related to continued competence for license renewal.
Do we want to continue, I'll come right to you. Do we want to, knowing that these two amendments are related to continued competence, look at 4161, 4162 together, give our comments, then we'll go to our public? What do you think?
Oh, I was going to say, legal's comfortable since the item was on the agenda as a packet, waiting until the end in order to get public comment, or if public comment is indicated, we can do it section by section. Either one works. I thought that question was good.
We like those words, legal is comfortable. Okay.
A
I
question.
like that direction, I mean. Go ahead.
The way it's worded, and maybe it's the comma that's throwing me off, but a minimum of 2 units must be related to ethics and healthcare, and 1 course shall pertain to culture relevant practice. Does that mean 2 units per ethics, 2 units per cultural competency, or it's 1 unit split, 1 and 1? Because it's not clear the way it's written.
This is exactly what the board
I know.
approved.
I know.
So, and
Now I'm looking at
for the second one, the conversation around that was a course without specifying or quantifying. Yeah, so it was just a course and gives the individual the flexibility.
So, okay, so the 2 units can either be 1 ethics and 1 cultural, and you'll get your 2 units in.
No, 2 units in ethics, healthcare, and then another course, TBD, on the number of units.
This is, I can clarify because I remember this discussion. So we said that of the 24 units that a person, a practitioner must do to keep in compliance, they must take at least 2 units that must be related to ethics, and one of those 24 units has to be a culturally relevant course. So we said that at least 2 of those has to be ethics. At least one of those courses doesn't matter, and then has to be the cultural competency, and then the other, whatever makes up to the 24, can be anything they want. But we specifically wanted an ethics course and a cultural competency course, and we didn't. I think we said that the ethics had to be at least 2 units because
We addressed it because of a public comment.
Yeah.
That called it out. We deliberated on it as a board. And really, it's the overall 24 PDUs of which we set a minimum to address the comments that came before. It must be about ethics. And the other, there should be 1 course and we felt that combined with the other direction that people might take on their PDUs, which is generally clinical and related to their area of practice, satisfied. And that's why we called these 2 out, because they're different. They may or may not come across these topics in their, I mean, we know they're going to, but you know what I'm saying, in their area of practice.
Yeah, I remember this discussion quite vividly, and I'd rather not recreate it here and just move on, because this is language we've seen and approved previously, and going over the language again would take up our entire meeting again. No, I know. I'm just.
I agree, but I just wanted to point out that we felt that those 2 areas needed to be addressed specifically every time they took their opinions. And then whatever they else they want to do, that's up to them. But these 2
Okay.
things we wanted to address specifically.
Any input from our, thank you, board members, by the way, for all those comments. Any input from our public? You're not mic'd.
I think I know the answer, but I want to hear it. So As differentiated from the previous conversation, these courses do not have to be board approved. Correct. That is only an advanced practice
Correct.
board approved. Okay, because I'm the chair of the California Occupational Therapy Fieldwork Council, and we have been offering these courses to the public for free for the last 3 years. And we hadn't gotten board approval, so I'm happy to hear they'll. My next question is, how are you going to announce this to the licensees, right? I mean, I've had a license for 32 years, and this is a change that I would have missed if I hadn't been at this meeting.
When it's closer to going into effect, we will put information out on the board's social media. We will have a couple of different ways that we'll announce it. One of the thoughts,
Licensing packet?
even the renewal, a reminder.
You shall provide us with your email address so that you can get an email.
We've been talking for weeks.
We'll also rely on you on the Fieldwork Council. As you know, we've done some work as well as, we'll rely on you as the chair of that Fieldwork Council to recommend ways for us to get this information out as well.
Oh, yeah. Yeah. Go ahead.
I just want to draw your attention to the course does not need to be pre-approved by the board, but it has to meet the criteria specified in 4161.3. What's that? I'm confused about how to read this.
Is it
A,
C?
1, 2,
It's,
3,
yes,
B, 1, 2, 3,
it's
C.
Yeah.
C, 1, 2.
Yeah.
Yes.
Yeah, so it spans page 5 and 6. So I'm sure yours does, but I just, for anyone who's listening to this, I just want to point that out.
Well, I think that's why we've been able to do it, because not everybody, fieldwork educators are on the council, but the council is run by academic fieldwork coordinators who are all with an academic institution, so
Yeah.
we can get through this
Yes.
for our institutions. So, okay, thank you very much.
Thank you for your comments. And for a thank you for helping us with the outreach on this. When the packet's approved, you know. Exactly. In case I don't get to tell you when I see you at conference. Okay. Okay, here's what's before us. It's 12:23. I do, any further discussion? Any further public comment? Okay. Throughout these, just as a quick, we did have comments come up with during 4102 about the email. Is that satisfied, or is there something we have to put as a recommendation before we go to motion?
Did we decide?
I do them together. And then in hand therapy, we heard verbally from board members, and we heard a lot of comments from our experts here and subject matter experts that were comfortable. 4152, 4153. We clarified on 4154 the difference between advanced practice having to be board approved, and we did take we did take 4161, and then looking at 4162, those were two that we were going to look at together. So everybody look at 4162, and if we're comfortable with where we've gone, if our public feels like they've had enough time to comment, then we are at a point where we're ready for a motion.
This is legal. If I can ask, for the 4102, what is the intent of the board?
So the question from legal, Helen, what is the intent? What I heard, I don't know how to say this to you, because what I heard is they're putting it into the motion, and so I don't want to, you're going to have to speak, I can't.
I think we decided that we were going to set this motion where you got the executive officer.
And that would be fine, but we need to know what the board wants. Do we want to err on the side of strongly encouraging, if not requiring, an email address when you have one for for an additional contact to the licensee? Or do we want to leave it fuzzy with may, and even if they have one, it may not be an option for the board to contact them?
I think it was because the executive director said that this was based on other boards'
It is.
email policy. So I think we wanted to leave it that if at the direction that it felt that we needed to keep it that way because that's what the other boards are doing, then we'd go with that. But if it isn't, that way, then we can leave it kind of.
Well, I want to, if I may, just add to that, to Board Member Doe, it's a little bit more than just what other boards are doing, because while that's a nice to have, we're a board that stands on our own, and one of our criteria is authority. So we have the authority here. We've deliberated a lot back and forth on the word shall and may. Switching the word now feels like the board's going backwards because we've deliberated on this word. That's the history. That's one from many years, including the time you've been on the board, but many years before that. Secondly, also when we look at this particular, we had some discrepancy on who thought it was unclear and who thought it was clear. It was perfectly clear to me. That doesn't mean anything. We're a board. And it was unclear to some board members. So I think there's a number of reasons, but I think we have to come to a conclusion on, is there an action for our executive officer? And it would be great to have that discussion and go back to public comment before we go to motion.
And can I just clarify, we did not finish 4161. We didn't talk about doctoral capstone, and then we didn't go to 4162, correct? We stopped at continuing competency on page 5. Were you just assuming
So-
everyone's making comments? Is that what?
So 4161 includes page 2, the whole doctoral capstone.
Correct.
So that is and I had stated it twice, but it sounds like I was unclear because the question came back a third time. 4161 and 4162, we dialogued on them together all at once. About 3 minutes ago, I asked anybody if they had any comments on 4162. But again, just because it's clear to me doesn't mean it's clear to.
President Miller, is it true that we've seen this language and approved it at previous meetings?
Quite many. You want to weigh in on how many you think that is?
I've lost count.
I think we've done it at every meeting.
Yeah.
I've been on.
So rehashing and revoting on set policy is certainly something we could do, but I don't feel that it's a good use of my time or the board's.
I understand, but the discussion at the beginning says we were going to go by every item, and so the assumption that we went from every item to just a lumped item at the end is different. So I just want to make sure that was clarified. We changed it.
So in the overarching theme is this language, does, on this particular item, will the practitioner read this and will the consumer be safe? Will they understand what's before them and will that consumer be safe?
So going back to the email issue, I mean, to me it was clear, but there were a couple board members that said it wasn't clear. So that, I'm going to leave that up to them to decide how they want it placed because I'm fine with the way it's written.
And since I was the one who brought it up, I'm fine with it. It's clear to me, it just wasn't like fair enough towards, oh, you're required, but you're not required. But because it's important to us to receive as many email addresses as possible, let's keep the language stronger. It encourages them, and they think it's more of a requirement versus you don't have to. So I'm okay keeping it the way it is.
I can take a quick pulse and then we can get to a motion. I'm okay. Yeah, Board Member
I'm good.
Morcos is okay. Board Member Cabrera, are you okay?
Yes.
I'm okay, you're okay, okay. Board Member Bookwell, okay, so we have consensus down here, what's happening, okay, all right. So, does our public want to weigh in one more time before we go to motion? Okay. We are at a place where we need a motion on the language for this regulatory package for item 9.
I'd like to make a motion.
We-
I have it.
Oh, you have it.
Yeah. I move to approve the proposed regulatory text amending sections 4102, 4151, 4152, 4153, 4154, 4161, and 4162 as presented and direct staff to submit the text and other required documents to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review, take all steps necessary to initiate the rulemaking process, and set the matter for hearing if required.
We need a second.
I'd like to second.
Board Member, Vice President Marcos made the motion, Board Member Cabrera seconded, and if we could take roll.
Board Member Bookwalter,
Aye.
Board Member Cabrera,
Aye.
Board Member Palovich. Board Member Witzelbach.
Yes.
Secretary Doe, yes. Vice President Marcos.
Aye.
And President Miller.
Yes.
Motion carries.
All right, so here's where we are. It's 12:32. It's time to take a break. Oh,
I move
sorry.
to delegate to the executive officer the ability to make edits to the text that are consistent with the law and substantially similar to the text of the policy approved by the board at the meeting.
I'll second.
That motion was made by Board Member Bookwalter. The second was by Vice President Marcos. Do we have any comment from our public? Okay. On either? Okay.
Board Member Bookwalter,
Aye.
Board Member Cabrera,
Aye.
Board Member Palovich.
Aye.
Board Member Witzelbach.
Yes.
Secretary Doe, yes. Vice President Marcos.
Aye.
And President Miller.
Yes.
And motion carries.
So the board is going to adjourn for a lunch break. And one second. Are we going outside? I need to understand how much time to give. That's why I'm asking this question. Okay. The board is going to adjourn for lunch. We are going to resume at 2 p.m. We will continue on with our next packet item. We have one more item that we have to go through like this, and then we have a couple of other items to round out our day, and maybe about 2 more hours of work with that. Okay. Board is adjourned. The board meeting at 12:33, the California Board of Occupational Therapy here at Samuel Merritt. Thank you.